Good evening, everyone. My name is Victor Doering da Silveira. I am a researcher at the Getúlio Vargas Foundation's Law School Center for Education, Research, and Innovation, and it is my great pleasure to serve as mediator for this panel today in the context of the 15th CODAIP, Congress for Copyright and Public Interest. Our theme is copyright reform in the digital age, a subject that has puzzled both legal scholars and policymakers for the last decade. How do we update copyright to deal with the innovations brought by the development of the internet? What are the limits of analogic copyright frameworks, as well as hardline strategies to fight digital piracy? What is the ideal way of dealing with users' rights, as well as with user-generated content? What should be the powers and rights of intermediaries, social networks, and platforms in this new age, in the best way to deal with all the stakeholders? Today we have organized this panel to discuss these questions in a very substantial and articulate way with scholars with legal scholars with a deep background in the matter of copyright and copyright reform in the context of the Internet 2.0. So today I have the honor of doing this discussion, having this discussion today with the participation of these guests. We have here Professor Michael Geist from Ottawa, which is here to give his take on this issue, mainly from theoretical discussions and the Canadian experience. We have Professor Rebecca Tushnet from Harvard, who is here to do the same, highlighting the American experience and her research lines in the field. We have Professor Alexandre Pacheco da Silva, a colleague of mine from FGV, and the coordinator of the Center for Education, Research, and Innovation, who will talk about the particularities of the Brazilian case and the implications of copyright reform for innovation and the creative economy. And last but not least, Professor Carlos Affonso de Souza, director from ITS Rio, the Institute of Technology and Society from Rio de Janeiro, who is also a long-term scholar of the field, and who will talk specifically about policy issues and the latest development of copyright reform in Brazil, particularly in the light of the developments last year or two. I would like to note also that the Instituto Observatório do Direito Autoral will release during this Congress an open course on copyright and artificial intelligence, which will be ministered by Professors Marcos Vakovics, Lucas Rutz Gonçalves, and Pedro de Perdigão Lana. It will be five synchronous classes and 5 asynchronous classes, accompanied by a textbook for the participants to prepare previously. Even though the course will be open, there will be limited places, limited students, to allow for a more richer exchange of ideas among participants. If you have interest in participating, please don't miss this opportunity, and please come debate this theme that is so relevant in the field of intellectual property and new technologies. Finally, I would like to remind those who are watching us on YouTube that you can make questions for the duration of this panel in the YouTube comments of this video, and in the final 20 to 30 minutes of this panel, we will take some time to tackle some of these, choose and tackle some of these questions takes and give our participants the opportunity to give their takes on the issue. Now, without any further delay, I would like to pass the word to Professor Michael Geist, who is absolutely free to expose to give his keynote, expose his views on this subject. Professor, thank you very much for being with us today. I extend this thanks to all participants in the panel, and please, the floor is yours.
Great. Well, thank you very much, and thank you so much for the invitation to come and participate. Brazil has been, I think, really so innovative and really at the forefront very often on many of the debates. I mean, thinking back to Gilberto Gil and others, where when it comes to copyright. So it's always a real pleasure to have the chance to come and speak. And so I'm going to share my screen. Hopefully this will work. As I look for my presentation. Sorry, this is always, it takes a moment. Great, and so I'm going to use my my time now to really try to bring people up to speed on where Canada has been over the last 15 or so years, as we've 20 years, as we've grappled with copyright reform in a digital age, and then tell you a bit where we are right now and with a little bit looking ahead. And we'll save some of the opportunity to posit around what we should be doing and some of the broader considerations that were so nicely articulated at the opening for some of that discussion that will follow. So just Canadians don't get that many opportunities to sort of tell everybody what's been going on in Canada. So this is one that I feel like I have to take an advantage of a little bit. So it's going to be a Canadian tale in 4 parts. I've broken up what we've seen take place in Canada over a 4-year period. It starts with the 2012 reforms. And I think it's probably useful to note that the reforms that Canada enacted in 2012, combined with a series of important decisions from the Supreme Court of Canada. In fact, there were 5 copyright decisions handed down in a single day, known as the copyright pentology, was in many respects the culmination of really that first phase of grappling with copyright in the digital age. I think pretty fairly, it would be fair to state that it dates back to when the WIPO Internet treaties in the mid-1990s. Canada didn't really start taking issues around copyright reform that seriously or that intensely, probably better framed, for a few years, at least 5 or so years, I think, after those treaties were signed. But in the early 2000s, we began to really engage. We had in Canada a series of minority governments for some time, and copyright always proved to be a bit of an intractable issue. It always seemed difficult to give it the kind of priority that proponents of reform would have liked to have seen. And so what we often ended up with was simply an inability to get things passed. Governments would study the issue. Occasionally we would get a bill introduced, but it took until we had a conservative government that had successive majorities that it was in a position to really see things through. And there's a separate talk that I don't really have the time to talk about right now, but happy if we want to get into it later on. That is a really interesting evolution of how we even came to the 2012 reforms, where the government had initially proposed provisions that were largely aligned with what the United States had been doing. And it was really the United States that was putting an enormous amount of lobbying pressure on Canada to largely match what we saw in the United States. In that way, I think it's fair to say Canada, similar to many other countries, where as part of trade negotiations or other sorts of issues, they face those external pressures. And interestingly, this was at a time when social media was just emerging, and social media and other tools were used to raise public awareness of what the government had in mind, to push back against what the government had initially proposed. And so where they landed with the legislation that I say passed in 2012 was proposed a couple of years earlier, was, I think, really, in many ways, stands as one of the most balanced and I think fairly reasonable sets of reforms that we've seen in almost any jurisdiction in this current environment. That's not to say it's perfect. It by no means is is. And in fact, I think you can make the case that when it comes to copyright reform, so long as everyone's a little bit satisfied and a little bit unsatisfied, there's probably at least an effort to try to address some of the considerations and concerns from the various parties. The frustration often comes when what we get is very one-sided. And so there is a long list of things that Canada included. But just to highlight a couple, there was an expansion of fair dealing, which would be the Canadian version of fair use, by incorporating some additional purposes. There were a series of provisions that were designed, they said, to catch up with technology. In reality, it was still behind because it was thinking about recording television shows and things like that. It didn't quite anticipate the streaming world that even by that time was really already upon us. But nevertheless, there was an attempt to legalize, by that point in time, fairly commonplace activities that technology had really facilitated. There was notably a provision for protected non-commercial user-generated content, looking at the kind of remix and UGC that was taking place and trying to provide safeguards around that. It was a really interesting provision. I think in practice, it has proved somewhat less effective than we might have hoped, as some of the largest platforms just don't implement their systems or architect their systems to accommodate some of these kinds of more niche rules, shall we say. And so what we end up with is the same US DMCA type approach, as opposed to taking advantage of the kind of the specifics around user-generated content. We also, it is fair to note, ended up with DMCA-style rules when it came to anti-circumvention, the so-called digital lock issue, which at the time was really the US's biggest lobbying point. And we also adopted a notice and notice system for ISP liability, for internet provider liability. That came as a rejection of the notice and takedown system that exists in the United States, and reflected in some ways what was at that stage common practice amongst many of the large internet providers and the content industries. Some criticized it as not going far enough, but it's a provision that has actually stood the test of time and continues to be in use in Canada, although has been litigated a number of times in the courts for what is really required of ISPs. So it was a fair amount. This law was called the Copyright Modernization Act. There's a fair amount in there. It's also, I think, notable for what is not there. For example, there was no extension in the term of copyright. Canadian copyright law, at least for a few more months, stands at the Berne Convention standard of life of the author plus 50 years. And despite pressure to extend by an additional 20 years, we stayed at life plus 50. Now, in addition to the reforms that the government took place, Canada's Supreme Court by that point had become exceptionally active when it came to copyright-related matters. And it started also in the early 2000s in a number of different cases where it had begun to articulate a vision of true balance in copyright, talking about both the role of creator rights, but also of the centrality of user rights, borrowing, I think, really importantly from Professor David Vaver's work, where he had talked about that. And in fact, I run a regular podcast, and for my 100th episode a couple of months ago, Professor Vaver came on and really gave a masterclass, I thought, tracing through the development of user rights through the case law and how it found its way into Canada. And so we started to see the emergence of the court becoming very active. In 2012, there are 5 decisions that deal with everything from fair dealing to the question of whether of research and whether it covers consumer-related issues, educational-related copying, technological neutrality comes to the fore. And in just about every case, I think it's fair to say that the court not only seeks to strike a balance, but I think really demonstrates for courts around the world what it means to provide something more than just lip service to the importance of users and the role that they play. And so we get really embedded within Canada this notion of user rights. It's not articulated specifically or called user rights in the statute, but it is the way that the court has interpreted it. And so that 2012 process, as I say, is the culmination of more than a decade of both litigation and developments within the court, within lobbying and the like. And so you'd think that various parties would take a breather, but I'm not sure that they really did. We get what I think was largely the aftermath, which takes us 2012 roughly to 2012 to roughly 2018. We get a number of additional fair dealing cases, and so the court had already pushed, as I say, quite hard towards user rights and more balance within fair dealing. In some ways, a stronger fair dealing that looks a bit more like a fair use type provision. We get a series of some pretty interesting cases. The York University case is a case I will come back to, because we just a few months ago had this case that kind of starts around that time frame and takes nearly 10 years to work its way through the court system before it ends up before the Supreme Court of Canada. We get other cases that look at everything from the role of Crown copyright, to what extent does the government hold copyright or own copyright in its works, to other questions around technological neutrality. So the litigation side remains very active. And I guess just as a caveat, it's worth noting that in Canada, we aren't particularly litigious, at least not compared with some other jurisdictions. So when you see this kind of list over this time frame, from a Canadian perspective, this is a lot. And in fact, I think it's fair to say that in the last 20 years, we probably have had more copyright cases. We certainly have had more copyright cases at our Supreme Court than we had probably in the prior 50 to 80 years. It was just a large number of these cases. We had a number of other issues come to the fore, just to highlight two on there, but I'm happy to answer questions about anything else if you like. One is the role that treaties play in reform along the way. And so, of course, there is the Marrakesh Treaty that many of you will be familiar with, I'm sure, that speaks to the question of making works available for the visually impaired, and Canada is a participant in that. There are still some debate as to whether or not we have implemented it in an effective enough manner. And one of our clinics at the University of Ottawa, SIPC, which focuses on public interest works or issues, has begun work that examines some of the concerns in that regard. There are also a series of treaties. ACTA, the Anti-Counterfeiting Trade Agreement, had just concluded around 2012. And then through this period, we get things like the TPP, the Trans-Pacific Partnership, which later becomes the CPTPP, which also creates some pressure for reform. And then around this time, of course, the U.S. has elected, during this time frame, the U.S. has elected Donald Trump, and we get a renegotiation, or the start of a renegotiation on the Canada-U.S.-Mexico trade agreement, ultimately leading the NAFTA agreement, ultimately leading to the USMCA a little bit beyond that. The one other issue that I think is important to note is the emergence of website blocking as a major issue. And we see that in a lot of countries. We don't see this, I believe, quite as much in the United States, but certainly throughout Europe and in many other jurisdictions, website blocking becomes one of the big sort of touch points when it comes to copyright-related issues and the role of intermediaries. This is driven largely by the emergence of unauthorized streaming services and the argument that the only way to stop some of those streaming services, who often are located outside of the jurisdiction, streaming live sports and other sorts of content, is by requiring active blocking of those sites. And so we see it in a lot of other jurisdictions. In Canada at this stage, we get, interestingly, the telecom companies actually supporting a blocking system. That makes Canada a little unusual compared to some other countries, and it reflects the fact that our telecom companies also happen to typically be the owners of our largest broadcasters. And so they own both the carriage and the content, and have sided at times with the content side of the business to argue for site blocking. They lobbied for the creation of this through the telecom regulator in Canada. But interestingly, there was a large campaign trying to counter that, and there was a decision made not to move forward with site blocking at that point in time. Part three, just to make sure that I'm doing okay on time. I think I'm fine. Part three involves, I'm just giving it sort of 1 year, and it is the copyright review. And so I mention this because as part of the 2012 reforms, one of the things that the government decided was that there should be a mandated or mandatory review every 5 years of the copyright legislation, essentially saying that we were never going to find ourselves in the same place again with laws that were viewed as being out of date. And so this process takes place roughly 2018. It concludes in 2019. The main review takes place, the authoritative review takes place at the industry committee. It's a very extensive review. It really does hear from a very broad range of stakeholders as an effort to reflect on what has worked, what hasn't worked, and what are the important issues going forward. And by and large, the committee concludes things are going okay. It argues actually for an expansion again of fair dealing and for some restrictions on the anti-circumvention rules. But by and large, it rejects claims that the Canadian reforms had been highly problematic. It rejects as well, or it says it's not a fan of copyright term extension, extending the additional 20 years. It says if we do so, as if potentially required to do so by way of a trade agreement, that we should at least find ways to mitigate some of the negative consequences. For example, create a system whereby that additional 20 years would only come to those who formally register for it, falling outside of the formalities side of Byrne, because this would be an extra 20 years. It would be essentially life plus 50 plus 20. Was their conclusion. They also say they're not comfortable at that stage with website blocking, but they do recognize that technology, especially around text and data mining, or was sometimes referred to as informational analysis, might benefit from a new exception along the way. There is a second report. It is not the authoritative report. It was designed to sort of provide a political compromise from the Heritage Committee, which has traditionally been more affiliated with creator-related concerns. It was supposed to conduct a review on compensation systems, but it effectively ended up simply doing a repeat of the same consultation without hearing from the broad range of stakeholders, hearing really from a more narrow sector. And I've described their report as the Costanza report, which is a reference to George Costanza from the television show Seinfeld, where there was an episode where Costanza does everything the opposite. And the Heritage Committee is basically the opposite. And just about everything that the Industry Committee had concluded, the Heritage Committee would concluded, as I say, the opposite. All of which, in my last couple of minutes, takes us to where we are now. There are a few things that are worth noting. First, the USMCA is concluded, and that does raise within Canada the prospect of some reforms, most notably on the issue of copyright term extension, which there is a requirement that we extend the term of copyright. There is also some provisions that deal around things like the CDA Section 230, not strictly copyright, but does touch on the role of intermediaries. Canada's notice and notice system is preserved in that agreement. And the government, despite the fact that we had this extensive hearing and these studies, essentially say we're going to do this again, or at least we're going to launch consultations on many of these issues. And so earlier this year, they launched 3 separate consultations, one on how to implement term extension, another on what role for intermediary liability, particularly around the platforms, and the third around the text and data mining, artificial intelligence related issues. So there were already studies and recommendations. The departments have decided to ask yet again, and there is some expectation that we will see at least some reforms in the coming year, perhaps. We just had an election in Canada. We'll see where things go. I think it's reasonably likely that we will see some reforms, certainly on term extension. The Supreme Court of Canada, just in the last couple of months, handed down its decision in the Access Copyright York University case, and it largely offered a resounding victory for the university. While it did not reach a firm conclusion on the fair dealing issue, it certainly hinted that it was supportive or had problems with some of the earlier decisions that had expressed concern with York University and fair dealing. It pointed to some of the errors that may have existed in that decision. But it fundamentally also argued that any sort of tariff that York would have been required to pay was not a requirement. It was not and could not be made mandatory, which was really ultimately the central issue in the case. And that will be another issue I would expect for lobbying, with efforts to try to, in a sense, overturn the Supreme Court decision through reforms. Finally, and with this I'll conclude, website blocking has taken on heightened importance in Canada. We have had at least one federal court case that has upheld website blocking. It's gone from both our lower federal court to our federal court of appeal, and there is currently an application for leave to appeal to the Supreme Court of Canada. We'll see if the Supreme Court takes that case. Even if, whether they do or not, rights holders who were happy to see website blocking orders, which are used to require sites to block specific IP addresses, try to expand that scope into what are known as dynamic injunctions. They would like the ability to, on the fly, in real time, provide ISPs with new IP addresses to block as certain events are taking place. They have been quite strategic about this and have used NHL hockey games, ice hockey games, as being the sort of touch point for this case. It's very popular, of course, in Canada. And so the idea that there could be infringing activity on our national sport is designed to really curry favor with this particular approach. We are starting to see a number of groups say, hold on a second, the level of oversight that is needed for this kind of approach, where there's almost an immediate requirement to act, raises a whole set of new issues and a new set of concerns. So very active in Canada. That's where we've been at. And I'll stop there. I'll stop sharing, and I will stop there and look forward to the other presentations and the discussion later on.
Thank you very much, Professor. I have to note that we at FGV, me and Alexandre have been working in the past year, particularly in the past year, on a project about copyright reform, mapping experiences in copyright reform around the globe. And Canada is one of the most intriguing examples, because it seems to escape many trends in copyright reform, which you see in some European countries and some Latin American countries, and in many regards, the notice and notice regime, some particular attempts to copyright reform right in the beginning, which don't seem to really converge with the whole pro copyright holders interests, SOPA and PIPA, and it's a very particular reform. But it is interesting to note, as you put in your presentation, how the copyright reform in Canada has gone forth and back many times, and how it seems to be an ending discussion on the matter, even for a country that has made its own reform about 10 years ago, and it doesn't seem that this is a close subject. This was only a comment with something that intrigued me a lot in your presentation. Now, without further ado, I'd like to pass the word to Professor Rebecca Tushnet. Professor, thank you very much for being with us here today. Please, you have the word.
Great. So thank you so much. Hello from the notoriously litigious United States. There are many provisions of US law that I think are potentially a model for other regimes, in particular, fair use, even aspects of the 1998 Digital Millennium and Copyright Act's notice and takedown system. So like democracy, I tend to think that notice and takedown is pretty much the worst of all possible systems, except for the others that have been tried, although I expect Professor Geist could defend notice and notice as superior. There is currently a push to get rid of notice and takedown in the US and replace it with a European-style filtering mandate, which would be terrible. That proposal seems to be stuck for now in the general political dysfunction of the American system. I'm also not going to talk in my presentation about the Music Modernization Act, which is now a couple of years old, which got enacted in significant part to deal with the rise of online music services. And I'm also not going to present about the recent institution of a copyright small claims process, which is designed to make it easier to go after small infringers. And I think the expectation is that they're almost all going to be found online. So this too is a digital reform, despite not being targeted only at online behaviors. I'm happy to talk about any of these issues and the larger copyright reform picture during our discussion. But in my initial presentation, I just want to focus on some mistakes that the US made in dealing with digital education specifically that I think other regimes may be able to learn from. And if you think of the US as fundamentally a common law system, the level of detail in our non-fair use exceptions may be surprising, but actually puts us, I think, in the mainstream in many ways of how internationally copyright reform is done. So in essence, the digital transition made non-fair use-based copyright exceptions more detailed and much worse. And so I want to walk through the relevant US copyright exceptions for education and what I see as their key weaknesses. In particular, we've put too much emphasis on distinguishing different types of copyrighted works and distinguishing different exclusive rights, rather than writing comprehensive exceptions that cover any work and any means of making a work available to students. In addition, and making that worse, there's just too much emphasis on minimizing uses as a goal in of itself, including uses that would be perfectly lawful in face-to-face teaching, simply because copyright owners want any exemptions to be as small as possible, without thinking about whether the requirement of smallness is pedagogically justified or, in fact, economically helpful to copyright owners. The affected uses are indeed still pedagogically valuable, even using digital education. So my pitch to you is that digital copyright reform shouldn't kill the practical utility of copyright exceptions that have at least as much value in the digital age as they did in the analog age. So to introduce this, I want to show you the educational exemption for face-to-face teaching. So this allows educators to perform or display works in the course of face-to-face teaching when they're in a classroom or similar place, unless for an audiovisual work specifically, you're using an unlawfully made copy. Note, we already have this distinction between types of rights. So this doesn't cover reproductions. Reproductions are dealt with mostly under the heading of fair use, or realistically, the copyright owners do not attempt to enforce rights against making multiple copies for classroom use, in part because it's specifically listed in the introductory definition of fair use as a favored purpose for fair use, and in part because they don't necessarily want the public backlash that comes from harassing teachers. So if I bring to class a poster or a t-shirt to show students, that is a public display. It is generally allowed under our first sale doctrine if I have a lawfully made copy, and it is also allowed under 110.1 because I'm engaging in face-to-face teaching. Now, because I teach copyright law, some of the examples I use in teaching include works that were deemed infringing, therefore not lawfully made. So first sale doesn't apply, but when I'm bringing in pictures, that's still covered under the exception for face-to-face teaching. However, there is this lawfully made requirement for audiovisual works. So when I teach about infringement findings relating to audiovisual works, 110.1 doesn't protect that. I have to rely on fair use. And this is just an example of the way in which the fair use comes in to sort of allow for things that aren't quite covered by other exemptions, but really should be. Since obviously teachings about what constitutes lawful and unlawful use so that students can understand it, I think is very much a legitimate purpose, pedagogical purpose. Now, there is also, coming up on 20 years now, Congress enacted some distance education provisions. At the time, people weren't sure exactly what way digital education was going to go. And because they were so focused on making these exemptions narrow, they pretty much went the wrong way on this. So the next provision in the law, 110.2, is supposed to cover educational transmissions. Interestingly enough, during the pandemic school closures, many teachers just did what they thought was pedagogically useful without necessarily knowing what the law allowed for. And this is a caveat about US litigiousness. A lot of what goes on in the US is based on beliefs about the law or fear of the law. Most copyright owners won't sue educational institutions. They're much more willing to send nasty letters. So often there can be deterrence even of legitimate conduct because the rules for educational exemptions online are too complicated for most non-lawyers to have any certainty about what they can do. But it is important to recognize as a practical matter that many US teachers during COVID did what they thought was pedagogically appropriate, regardless of what the law might have said if they'd had a lawyer sitting beside them. I mean, socially distanced, of course. So the details specified in the statute turned out to have little to do with how online education actually worked. One of the reasons that these provisions were so narrow was that publishers argued that internet educators have to pay for computers, software, internet access, teachers' salaries, and everything else. So they should also have to pay to use copyrighted works. But education is deeply underfunded in many areas of the US. And educational uses have many positive benefits for society that educators can't charge for, which is why education has long been a favored purpose for exceptions and limitations. So the copyright owners did not get everything they wanted by making this argument. Congress enacted this provision called the Teach Act because we like acronyms. You can see, once again, we have specificity about the rights, so performance or display, not reproduction. Again, reproduction is going to be covered by fair use, if at all. So if copies are made in the course of teaching, and the big thing here is they are much more likely to be made in the course of teaching online because of the RAM copy doctrine, which says that reproductions occur digitally, basically when they last long enough to have, I'd say, independent, economic or practical significance, which might happen in the course of teaching. So there will be more reproductions in online teaching than there are when I just bring my copy of a poster that I'm showing to class, which doesn't require any reproduction. So already things are changing. And the fact that this provision is limited to specific exclusive rights is more restrictive than the face-to-face version was, just by virtue of how technology works. There's also, you can see, distinctions made on types of works. So non-dramatic literary and musical works get a particular treatment. Reasonable and limited portions of other works are called out specifically. And then display, which is a different right from public performance. So images can be displayed, but audiovisual works are performed. Likewise, sound recordings or musical works. So you can display a work in the amount comparable to what's typically displayed for a live classroom session, unless the work being displayed is produced or marketed primarily for internet teaching. So you can already see the complications that have been added from the face-to-face teaching exceptions, and I'm not even close to done. So we have the similar face-to-face limitation on where you can do it, except we've changed that a little because it's digital. So it has to be part of classroom activities. It has to be directly related and material assistance to the teaching content, which is, you will note is not actually part of the 110 exceptions, where you could bring in something to entertain and amuse the class. You have to limit it to students who are officially enrolled in the course, so no observers. Again, this is just not they aren't thinking about how teaching actually works. So if someone is coming in to observe the teaching, which often happens in physical classrooms, and give suggestions to the teacher, not okay. The transmitting body has to have copyright policies that they provide to the students and apply technological measures that prevent retention of the work and unauthorized further dissemination. And can't interfere with technological measures used by copyright owners. What I really want to emphasize is how complicated these are compared to the exceptions for face-to-face teaching, which are much broader and simpler for a teacher to evaluate. So, among other things, can you show an entire picture to your class? It turns out that you can, because of the coverage of display. So displaying a full work is likely comparable to what's typically displayed face-to-face. But if we're talking about an audiovisual work, maybe you can't show the full work, which you definitely could in face-to-face teaching. Maybe showing a full audiovisual work could qualify as reasonable and limited, but there's now grounds for uncertainty. In addition, you have to apply, so I want to talk about the applying to the extent technologically feasible methods to prevent retention or dissemination. So that seems to mean that allowing student downloads of recordings takes an institution outside of the protections of the Teach Act, even though, especially for students who have bad wireless connections or bad internet connections, downloads are incredibly more helpful pedagogically than streaming only. But there's perhaps a prior question: what limits are technologically feasible? So as it turns out, digital rights management technology is expensive to run and not particularly feasible for an educational institution to implement. So if it's not technologically feasible, maybe you don't have to prohibit student downloads. But without answers to these questions, you can see why educators last year didn't talk much about the Teach Act. Instead, they just went about the business of teaching. So what should be done instead? And my argument is that exemptions should be focused on the people who use them for the social purpose for which they are instituted. They should be simple. They should be intuitive. For education, they should be focused on letting educators do what makes sense pedagogically, and therefore they should be shaped to be understood by non-lawyers. And this is pretty much the opposite of that. Because to really comply, you would want legal counsel to walk you through, and also you would need technological counsel to tell you, okay, what is technologically feasible to do to prevent retention? Even though PowerPoint slides and downloads of classroom recordings are simply not substitutes for even the works embedded within them. If you want to look at a picture, it's going to be much easier to just look at the picture as opposed to try and find the teacher's discussion of the picture in the middle of a class session. So similar lessons, I think, could be drawn from the US digital rights management regime in general. So the US made circumventing digital rights management technologies, or DRM, illegal and potentially criminal with very limited, very baroque, often quite practically useless exemptions. Meanwhile, DRM has not prevented the widespread availability of unauthorized copies of supposedly copy-protected works. So the US regime for DRM has provided far more barriers to good actors making legitimate uses of works than it has to bad actors engaging in piracy. It's just been pretty much a disaster, and a disaster that has expanded over the years as the Internet of Things spreads. More and more businesses have been using digital rights management technology anti-competitively in a way that has nothing to do with copyright. If the coffee machine maker is trying to prevent you from using competing producers' pods in the coffee machine and uses DRM to lock other manufacturers out, that is just not a copyright relevant act at all. And yet, the way that we wrote the digital rights management law, that they have an argument that the producers cannot circumvent that technology, and I think that unintended consequences of digital reforms that were not focused on legitimate activities that we want people to continue to be able to engage in tend to become too narrow to be usable. They're just not future-proofed, which is indeed one of the reasons that I generally find fair use to be a better model for exceptions than things like a very narrow model for AI research and data mining, for example, that might not fit the way the technology actually evolves. So that is my beginning presentation, and I'm excited to continue discussions. And
thank you very much, Professor, for this fabulous insight into the American experience. One thing that we have noticed, as we have who actually study this field, have studied this for a long time, and follow through the discussions on copyright reform, is that even before bills like SOPA and PIPA came along, you had this trend of this semi-draconian copyright bills, which didn't really seem to directly tackle the problems with digital piracy and punish actual pirates, but seem to make legal use, illicit use of protected works very hard for people who without any profit in mind, or with legitimate goals such as education, culture, etc. And while we didn't at FGV, while we didn't look specifically at the Teach Act, since it is a law from the early 2000s, and we look at bills from the new laws and regulations for the last 10 years, is a very good example of an outdated debate. So you have the situation in which the current regulations are clearly outdated, but at the same time, the propositions and attempts to modernize it don't seem really better. It's something that we have seen for a long time with SOPA and PIPA and its basic descendants. While the international discussions and the American and Canadian cases are really interesting and bring a lot of insight, now I think it's the time to enter on a more local approach, the Brazilian approach. As we all know, our current copyright law in Brazil is now it's from 1998, so it's 23 years old now, and we are looking into copyright reform. We have been looking into copyright reform for a very, very long time, and we have had a few interesting bills in this regard, and we don't seem right now to be going anywhere with it. When we look at new developments and discussion of copyright reform, we seem to delve into some outdated discussions and some really the dangerous ways to update our copyright law. And there seems to be a step backwards in regards to our copyright reform discussions that we were having 10 years ago, which were not perfect, but they seem to be leading us somewhere. So at this moment, I would like to pass the word to Professor Alexandre Pacheco da Silva from FGV, so that he can give us his own inputs and insights on the Brazilian case and on some challenges of exceptions and limitations of copyright law. Professor, thank you very much for being with us here today. Please, you may have the floor.
Thank you very much, Victor. It is actually a pleasure to be here and to share this discussion with Professor Rebecca Tushnet, Professor Michael Geist, and Professor Carlos Affonso Souza, especially because they heavily influenced my academic career and my interest in copyright. So I'm really glad to be a part of this panel. I was invited to explore the connections between the creative economy and proposals for copyright reform in Brazil. This is not an easy subject to discuss in 10 to 15 minutes presentation. Therefore, my focus here will be the importance of a copyright reform in Brazil, including specific provisions that allows new forms of content production through digital platforms. In my view, the current exceptions in the Brazilian copyright regime are not compatible with the characteristics of a creative economy, in particular with how people relate to materials protected by copyright and uses of protected content that do not harm the author. To illustrate my argument, I will tell an interesting story about the movie Ratatouille. I imagine that our audience and my colleagues here in this panel knows Disney Pixar 2007 film. And I would say as a synthesis for the story of the movie, that it is a beautiful story of a friendship between a rat and a young man working together to create amazing dishes. But how this could relate with my presentation, especially when we are discussing copyright reforms in Brazil. And the link here is that if we analyze the production of this film, there is nothing new in terms of copyright regarding the production, regarding the distribution, so on and so forth. However, in 2020, a 17-year-old TikTok user named Blake Rouse released 2 songs that he moved of style theater play based on the movie. So the idea is, imagine that you could create a Broadway a spectacle, a Broadway a theater show that could, as a matter of fact, that could translate the whole environment, the whole ambience of this movie. So after a few days of the release of these 2 songs, other users contributed with more songs. Soon, what began as a trend on TikTok quickly grew into a full-fledged project featuring the talents of several big-name Broadway stars, including Eden Lambert, Mary Testa, Priscilla Lopez, among others. YouTube users and few of my students here at FGV in our graduation program started to create videos and to find videos with people discussing scenarios for the musical, dividing the show into different acts, each one of them with songs, choreography, so on and so forth. And people really engaged in discussions about the musical and how the songs created on TikTok. It was not only a trend, but it was a way to express themselves throughout those songs and throughout the whole ambience that was created back then. And by the end of 2020, Ratatouille, the TikTok musical, had its world premiere as an online musical theater experience that will benefit the Actors Fund, an organization that provides a financial safety net for performing arts and entertainment professionals. So when I heard this story and discussed this story with students that were producing this type of content, I immediately asked myself, is this musical legal in Brazil? If we are discussing copyright reform in Brazil, should we ask this kind of question for the proposals that we have been discussing for at least, I would say, the past few years here in our country? How Brazilian copyright law would address this cultural phenomenon? Do Brazilian users behave in the same way as these TikTok users? And I'm exploring this topic also, saying that I have few students that behave as TikTok users, as I described before, but can we consider this a reality in Brazil to actually justify a copyright reform in those terms? And should the Brazilian copyright reform include provisions that allows this kind of practice? So let me start with the first question. And is this musical legal in Brazil? So at a first glance, I would say that no, it's not legal in Brazil. Under the Brazilian copyright law, copyright holders have exclusive rights over derivative works, creations that use major elements of a copyright works, for example, characters. And a TikTok user needs the copyright holder authorization to borrow a character from a movie and create a song based on this character. And the absence of an authorization constitutes a copyright infringement. In this case, the Ratatouille musical, the copyright holder, Disney Pixar, has given the project its blessing, saying that they love when fans engage with Disney stories. Given the circumstances of the case, I'm certain that Disney Pixar made the right decision, not challenge the TikTok community, but instead of relying on the goodwill of the copyright holder, should we, as a society, have a legal provision that allows users to freely engage with copyright materials without infringing the rights of copyright holders? In my opinion, I would say yes. But to what extent Brazilians behave in the same way on digital platforms? I had this and in a way, one question that's out a lot during those discussions, especially with different types of stakeholders, is can we observe the same level of engagement that we notice on Ratatouille musical as a part of the Brazilian culture? And in my opinion, and as an observer of some cultural expressions here in Brazil, I would say also yes. When we look to cultural expressions in Brazil, for example, in the hip hop movement in Brazil, or at least in some expressions in funk music here in Brazil, we can notice that a lot of those artists, they borrow characters from movies, they speak about public figures in our society, they retell stories in their own way, they try to engage and create their community, their communities using elements that they could identify themselves. They could identify their history throughout the years, so on and so forth. And I could say that last year, when I tried to identify some examples, we had an increase of users rapping about not only their reality, but also speaking about their reality, borrowing characters from Japanese animation series, from, for example, Dragon Ball, Naruto, among others. And it was very interesting to see that users, that people that are not professionals, people that are, as a matter of fact, amateurs in the music industry, they not only manage to form communities around their music, but they also incentivize their community to borrow their music, to share their music, and to try to grow their community regarding exploring this type of music, these songs that were produced and created from them. And if we're speaking about a creative economy with new forms of expression in content production throughout digital platforms in a way that the digital architecture matters to create this type, to create and distribute this kind of content, we need to ask ourselves how we will adapt copyright protection to an age of engagement in digital environments. In my view, a copyright reform would need to restructure the exceptions to copyright protection in Brazil. But the big question here, and the question that I think a lot of us are asking ourselves is how? How can we design a copyright reform that will actually include this kind of concern? And in my view, the first step to do that, it is by expanding the number of exceptions to the copyright regime in our country. For instance, we do not have in the Brazilian copyright law an exception that allows the use of films, short videos, and other materials for educational purposes. In a context where students seek for videos on YouTube and other streaming platforms to learn a topic of their interest, to use this to create communities, to share content, to try to explore a content in new ways, not having a copyright exception in this specific topic is definitely a problem for us. And in my view, the problem here is that we are not even discussing this matter nowadays in Brazil. We are not, during this pandemic period, we are not discussing how can we include this kind of concern in our copyright law. And there is a feeling in some groups here in Brazil that our copyright law is sufficient, or our copyright regime here is sufficient. And for me, it is not. And even though some of the copyright holders are increasingly encouraged to tolerate uses of copyrighted materials, our legal system should not of copyright holders. We have to be able to build solutions that legitimize valid interest in the context of our society. And I would say also that, at least in my view, we should create a general clause with clear requirements to be applied for legitimate uses of copyright materials, or as we could say, a fair use clause. I'm not saying that we need to import a fair use clause from other systems, for other legal systems, but I'm trying to state here that we need to discuss what would be the conditions from a legitimate use of copyright materials in a digital society. At least we need to create work groups to start to discuss this in our country and try to deal with those matters that are so important, especially if we are thinking about a digital society that will work with a lot of instruments that we usually say that are a part of digital platforms. But to end my presentation here, I would say that the case of Ratatouille musical on TikTok reinforces an important point, and that is my main argument here today, that copyright protection, it's not the only or the main form of encouraging cultural production. It is important to ensure the economic viability of cultural projects, but the reasons behind why people engage in cultural projects is more complex phenomenon than that. And for this reason, it should conclude my presentation, a reform of the Brazilian copyright law not only is necessary, but we need to realize and to discuss that there is a new dynamic of content production, dissemination, and sharing that needs to be incorporated into copyright protection in Brazil. We cannot depend on the tolerance of copyright holders in specific cases of the rules of digital platforms that recognize legitimate uses for copyright materials. We have to build a safe environment for this kind of cultural expressions, and we need to think about what would be the good solution and learn with experience from other countries. When we can observe how there is exceptions regarding educational purposes, how there is how can we actually build environment that will consider an economy that was built with a lot of aspects regarding digital platforms that we need to incorporate in our copyright reform. So I think that's it. I again thank you for the invitation, and I'm open to question. And I feel myself a privileged guy because I'm a part of this panel, and I'm very happy to be here. Thank you again very much, Vitor.
Thank you, Professor. This has been a very enlightening talk. Now, since we need to, since we're running kind of short on time, I will leave to make some comments later. But right now, I would like to pass the word to Professor Carlos Affonso de Souza, who do the last individual talk of this panel. Professor, thank you so much for being here with us today. The floor is yours.
So, thank you, Victor, and thank the friends of CODAIP for inviting me to this panel. I understand that we are short on time, so I'll be very brief because I don't want to put pressure on everyone's schedule. But the message
just one thing, we are short on time, but we have more than enough time for you to do your talk. So please don't worry about that.
But that's great. Thanks, Victor. That's super kind. But I'll actually be brief here. I want just to convey a message that connects to what Professor Geist told us about the journey into copyright reform in Canada, and it connects well with what Professor Pacheco was telling us about the copyright reform in Brazil that never happened. Because we end up making some comparisons about all sorts of changes that happen in Canada and all sorts of changes that haven't happened here in Brazil quite that much. And I felt that when Professor Geist began his presentation saying that he likes to address issues of copyright for a Brazilian audience because of the memories of the time in which Gilberto Gil was the Minister of Culture. Let me begin straight at that point, because Brazil ended up being known in a global stage when it comes to copyright by initiatives such as Creative Commons, open access initiatives, open software, free software initiatives. And that was a moment in the beginning of the 2000s in which we saw a lot of enthusiasm to modernize Brazilian copyright law. We know by now in 2021 that only a few parts of the law have been actually updated. And still, a good chunk of our legislation on copyright does not address a good part of the challenges that we face concerning copyrighting new technologies and especially internet. So the one thing that I want to mention right now is how Brazil switched from that moment in which we were sending out some signals on how could we promote an open culture, focusing on free software, focusing on Creative Commons and other ways of open licensing of copyright materials. And we come to a moment in which copyright have been used in Brazil for a quite different purpose, for a quite different function. And the main focus of my concerns here is a bill of law that we have right now in the National Congress. So that's majorly what I want to talk about. That's bill of law number 3227. It was presented to the Chamber of Deputies, to our House of Representatives, such to say, this year. And it is the result of a provisional measure that has been initially created by the federal government. And for those who are not Brazilian in the audience, a provisional measure in Brazil is something that is somewhat related to an executive order that you might have in the US. But in very specific cases, the National Congress might repeal a provisional measure, even without getting into analysis of its contents. If the president of the Congress decides that this provisional measure does not fulfill the requirements of a provisional measure. And that happened with that provisional measure, which is something that is much more related to the political landscape of Brazil. So I won't get into the details about what happened. But what I want to tell you is that right now we have a situation in Brazil that we do not have our copyright reform that we wanted, focusing on technology, internet, maybe AI, and focusing on enlarging and improving our copyright limitations and exceptions provisions. And in addition to that, we also have this new bill of law being discussed in the National Congress that end up using copyright as a way to counterattack or to restrict, and that will be a better way of saying, initiatives of content moderation done by social media companies. So this might sound weird, and this is very peculiar to the current Brazilian scenario. And I won't get into many details, but just to explain what's happening right now. So the federal government introduced a bill of law that needs to be analyzed by the National Congress that focus on addressing issues of content regulation. And this bill of law has two major provisions, one focusing on the moderation of social media accounts, and the other one focusing on the moderation of the content of social media in general. When it comes to social media accounts, this bill of law plans to have enforceable in Brazil this idea that social media companies can only ban, restrict, sanction in any way possible a social media account if the person that runs this account end up falling into some categories, such as failing to fulfill their debts or to pay for having your social media account. Most social media platforms are free or at least free, so that doesn't count that much. Second one, if this person tries to impersonate someone else, excluding cases related to parodies and satire. If this person end up violating intellectual property, and a couple of other situations. So that's the provision focusing on accounts. So as you can see, we are almost like inverting the logic here, in which we would have, if this law end up being approved, and hopefully not, it will create almost like an index of topics that could trigger either accounts or content moderation. But let's turn to content moderation. So on content moderation, this very same bill of law has a number of items that can trigger content moderation by social media platforms, such as incitement of violence, of illegal drugs, violence against animals, intellectual property infringement, and a number of other situations. And of course, a content could be struck down in Brazil if this bill of law is to be approved, if the company the social media company end up having and that's the language of the law, just cause to actually perform content moderation. So under this bill of law, there is this whole concept that you should have a just cause, proper cause to moderate either an account or the content that is posted on the internet. And then you're going to say, okay, I understand. You're going to tell me that intellectual property, and of course, copyright, is something that counts as just cause for accounts and content moderation. Is that all? No. And that's the final part of this very strange tale that I'm telling about what is being discussed right now in the National Congress. There is one provision on this bill of law that says that if the social media company, does not have a just cause to moderate content, the copyright holder of the social media post, the video on YouTube, the video on TikTok, on any other platform, can claim or enter with a review claim to the federal government, for the federal government to review this case and then analyze this case. And if this federal government entity that is not indicated in the bill of law, it's going to be up to a regulation, but probably it's going to be the Secretary of Culture, most likely. That entity that is part of the executive power, the federal government, would decide that a social media company has or has not acted with a just cause to end up having a content or account moderated. And what's copyright has to do with it? The trigger that will make this claim to the federal government in order to review if a content was strike down on a correct or incorrect way is copyright. So we are now going through waters that are really, really strange, because in the US, you have all the discussion of must carry theories as a way to restrict content moderation activities by social media companies. And in Brazil, it looks like we are going through our good and old conflict between freedom of expression and copyright that we are pretty much used to address in the past, but going through a very strange way in which we are using copyright as a way to counterattack content moderation activities by platforms. And of course, you can imagine how this can be pretty much connected to a very ideologically centric debate, and in which some social media users feel that their content are being restricted because of political bias or anything like that. And they will use copyright as a way to say, you cannot strike down my content, you cannot remove my content, you cannot label my content, because I am the author of this content, and therefore you cannot remove it, you cannot content moderate whatsoever. And that seems pretty nuts to begin with, because a copyright will not give you the right to say whatever you want to say because you're the author of something, because you created something. If you create a content that is offensive to people, it's not by saying, hey, I'm the author of this content, that a social media platform should not be able to remove this content. So it seems like if we are going into this direction, Brazil will not only putting a bad name to the tradition that we have on copyright, we could end up going to the very opposite direction. We are sending to the world a very bad example on how to misuse the protection of copyright in order to restrict content moderation in a time in which most people agree that we need more content moderation, when it's done, of course, in a very transparent, informative, and coherent way. So this is something that I think it's really worrisome, those recent developments in Brazil. This bill of law that I have mentioned is now being discussed in the National Congress. I think it's a development that we should always keep an eye on, and all of us here in this audience that are focusing and researching copyright law. I think that's a conversation when it comes to content moderation that you end up thinking at first that it's mostly connected to freedom of expression, but now copyright entered the room, and in a very weird stance, I would say. So this is something that I would like just to caught your attention, but I'll conclude here, Victor, because I think it might be a good addition to what Professor Pacheco has already mentioned on limitations and exceptions. I think that's another another update on what's going on in Brazil. It might be not a nice one, but I think it's one that is important for us to know and to be aware and prepared for the discussions that are coming up on this field. But then again, I would like to thank the friends from CODAIP for this invitation, for this conversation, and I'm looking forward to the questions and to debates that we might have in the time there's left for the panel. So turn it back to you, Victor. Thanks once again.
Thank you very much, Professor. I think your talk has been very enlightening and is very complementary to Professor Alexandre's talk, since he has basically treated on the ways in which artistic expression may be limited by a bad copyright framework. Your talk is more about how a very strange development in the copyright framework is actually leading to risks to other rights, including freedom of expression, including the liberty of contract. And this is very fascinating indeed, although worrisome, of course, since we are Brazilians and we live here. but it has been very interesting. We are really running out of time, and we do not have any questions from our viewers in the YouTube comments. I would like, though, to make one single question, which I think deals somewhat with all the perspectives that we have heard here, and it is this. Professor Michael Geis has touched deeply on the notice and notice regime for intermediary liability in Canada, and Professor Tushnet has mentioned it en passant. But it is basically it is a very particular regime which doesn't really have many equivalents. There is a similar regime in Australia, but it is not really widespread, and certainly not as widespread as the notice and take down regime, which seems to be pretty much the rising international standard even now. My question, and in Brazil, before we had the bill that Professor Carlos has mentioned from the executive branch, we had since 2019 a proposal in the Brazilian Congress, which tried to institute a notice and notice regime in Brazil to substitute the notice and takedown regime, which is applicable for intermediary liability regarding copyright in Brazil. My question is this, and any one of you who is interested and comfortable with answering that may answer it. When we talk about the notice and notice regime, does it make sense as a more protective approach, a more protective alternative to the notice and takedown regime? Is it more protective to free speech? Is it more protective to users' rights? Does it make if you're talking about reforming copyright in a way which enhances users' rights? Does it make sense to discuss notice and notice as a substitute for notice and takedown?
I'm happy to start. And I guess, I think having had it in Canada for many years, in some ways, I think it's actually a complement to notice and takedown. I don't know that it's entirely a substitute. And I say that because from my perspective, it does work very well with respect to the relationship between internet users, subscribers, and their internet provider. I think in that context, the safeguards that come in a notice and notice system, which include ensuring that users will not lose access to their internet service. There were days back during the time that we were recounting where there were countries that were thinking more about termination, about cutting off people's services. This provides a safeguard there. It also provides a safeguard against over their personal information, so it is not disclosed. So I think it is a privacy enhancing approach. And I think it also has the benefit of essentially saying that, you know, there needs to be some appropriate oversight in making these decisions, and that courts are better placed to engage in some of that. I should note that Notice and Notice really came out of the peer-to-peer world where there was nothing to take down, and the peer-to-peer transactions that were existing at the time were being used as an excuse to either cut people off from internet services and the like. And so this was a response to do that. I don't know that it entirely solves the question of other kinds of platforms where the issues are more content related. And in those contexts, it's true that many of these platforms use notice and takedown, even in Canada. I guess from a Canadian perspective, what I would like to see in even if we do by default see some notice and takedown used by platforms, is that their takedown system better reflect domestic law. And so the frustration is that it's not just that notice and takedown might become the default standard, it's that US law as part of notice and takedown becomes the default standard for many platforms. And so when countries, and Canada would be one, establish variations on that, for example, protection for user-generated content, which I believe to be truly speech enhancing, very helpful from an expression perspective, that is not respected by the platforms because they simply revert to what's easiest, which is the US approach.
So
fascinating, Professor, please.
Yeah, I would love to weigh in too. So, you know, I don't think that we're actually very far apart on our views. You know, let me say a couple of things. First, you know, part of this is about variety, right? So if you have, you know, unauthorized download sites where the business model is, you know, download or stream entire works, notice and takedown has a strong appeal versus notice and notice. Like basically these sites know that, you know, things are not right. And on the other hand, right, YouTube is actually a very different platform than an unauthorized, that a site that's optimized for, you know, unauthorized streaming of full copies of things. I am not sure that there's a way to get YouTube to honor Canadian law, especially since it's not actually the DMCA, the notice and takedown regime, that's actually interfering. It's actually the side agreements that they've cut with, you know, major record labels, major movie studios, and it's those that you would have to override to get the user-generated content protections to have their real effect. Because right now, YouTube will just say, "Hey, you know, our contracts with our partners say that we can do this, and you know, and then the terms of service say that we can do this, and we've agreed. So sorry, you don't get to appeal this one because it was taken down because our partners didn't like it." And I just want to note I don't know if it's an irony, but it relates to Professor Souza's discussion in that. So what Professor Geist is actually asking for is for local law to override what, you know, YouTube would like to take down because of its own economic interests. And that looks good if you like your country's law, and it looks bad if you distrust your country on what should or shouldn't come down, especially with things like, extreme nationalist content or, pro anorexia videos, right? And this is just a deep dilemma and copyright owners for a while, I think, thought they could sit this out, but are increasingly getting swept into these broader discussions in various ways. So I would say, in terms of having national laws overriding private platform terms of service, like, be careful what you wish for, or we're going to need to figure out some set of international human rights principles that that affect which things can be overridden.
Yes, it just seems that we're going back and forth a lot with the intermediary responsibility, intermediary liability discussion in terms of seeing a problem and wishing for a private or legal solution for this problem, and then just wishing that we hadn't done that in the first place. And it seems like with the whole disinformation discussion, taking into account that is actually harmful versus seeing laws being passed, such as the European regulation, which just seem to affect free speech in a bad way. And so, yeah, I think this is a pretty interesting way to see it. I'll have to end the panel now, since we have passed our time for a bit. I would like to thank you all so much for being able to talk with us here today, Professor Alexandre, Professor Carlos, Professor Michael, and Professor Rebecca. This was a really fascinating talk. The whole panel is on YouTube permanently, so you can access it easily. I will send you all individually the link later for your convenience. But right now, I would like just to give big thanks to you all, and also to all of our viewers who are following us on YouTube, and to Alice Lana, who has helped to organize this panel, and to the whole organization team of CODAIPE, who has worked so hard to make this all happen. So right now, I'm ending this panel, and have a good, and wish a good evening to all of you.